Hi, good evening everyone. Today is among the last chapters that we will be doing for your part B of your ECIPL, the new syllabus. We've covered almost all the chapters, trademarks, IPR, patents in complete detail. Not a single question will come outside of it. Okay, even Trademark Act 1999. All the laws we have completed, and I cover from the module every single topic, okay, in proper detail and a really rapid manner so that your time is saved. Now, before I start, I need a confirmation from your end if I'm audible and visible to you all. Also remember, closer to exams, I will be taking my signature marathons, okay, where in a short span, in 1 day or 2 days, I will cover the full portion. Okay, and there will be a lot of revision lectures as well. There is a dream batch announcement still left to come. Okay, right now I'm covering some of the new chapters which were not there in in the old syllabus. Okay, so before I start, I need you all to confirm if I'm audible and visible to you all. Okay, so and those who haven't joined the WhatsApp group in the description, please go ahead and join. The link is also on the chat box. Okay. So I need a confirmation. Okay, Akriti, thank you so much for confirming. Now we will be starting. I'll tell you how we will be doing this chapter. I want you to open your modules, ICSI modules of the new syllabus, and just be with me. I will be covering almost half of the chapter today in depth, and the other half I will do it tomorrow, and we will complete the entire topic. So without further ado, let's start with the lecture. Good to go. I just need a message GTG from you all in the chat box. That is good to go, and I will start with the chapter. You can keep your distractions away. Okay, Suresh, thank you so much. Sona, great to have you again. So just GTG in the chat box, and I will start with today's session. Okay, it's a very interesting session as well. Okay, and in my early age moment, I was a young lawyer. I just cleared out my law. Cleared out my CS, and I had joined a company in which they were asking about copyrights as well. So I will be sharing that today. Let's start. Great. Hi. So we will be starting with the copyright law in India. Copyrights is one of the most important intellectual property rights in India. Now when I say copyright as well, so I also am a copyright holder. I have written a book on GST, and I have published it on various platforms including Amazon, Flipkart, etc. So I have a copyright on that work. Now what is a copyright? What the benefits the author gets, we will see. First, the law relating to copyright is covered in India in two forms. One is in your Act 1957, and through the latest amendments, that was in the rules 2013, very important and notable provisions have been introduced. All we will be discussing today. Now in the introduction of copyrights, we are trying to understand what is a copyright. Now if you see any of our classes notes, you will see this mark copyright. You go to the website, you will see this particular copyright. Now, copyright is basically a right given to creators of their literary work, that is your writings, books, novels, scripts, all of that. First, it initially started with literary work, that is your writings. It extended to dramatic works as well, musical and artistic work as well. So if today I will have a song, the song will be copyrighted. If I have a drama, let's say of the Shakespeare Romeo and Juliet drama, will be copyrighted. Nobody can copy, make that drama, make a movie out of it. That all cannot happen. Even for movies, no part of the movie can be represented, no song of the movie can be represented without giving royalty to the owners. And now we also have sound recordings. So the ambit of copyrights is not only books, It has now gone to computer softwares, that is even softwares are copyrighted. It has gone ahead to artistic work, so singers performance on YouTube, creators, content creators. If you try to copy someone else's content, you will have a copyright strike. So the Copyright Act protects the creators, content creators, from any unauthorized use. The term copyright is to signify, to show that the creator has a right to copy his work, to make adaptations of his work, that is to make remixes, to make any kind of variations in his work. Only he can make changes in his work. To license it, that is assign it to someone else for royalty. So all that, or to completely sell also. So these are the rights of a copyright holder. And it is an exclusive right to the creator. That is, only he gets a right and he will further decide what he wants to do. The law in India we saw is 1957, and the object of the copyright law is to reward and protect the creators. So they will, since we are protecting them, that nobody else except them can use their copyright work, they can earn by licensing it to others. Let's take an example. If I have copyrighted a software, I have built a software, that software I can give it to someone, that listen, you can use it in your computers. And or very famous, if I am a singer, Arijit Singh, or the famous A.R. Rahman, okay, so when they have songs, they have a copyright over the songs, they can license it, assign it to certain movie makers. Rajkumar Hirani, they can give it to Atlee, he's a famous particular movie maker. So you can give it to them that listen, this is my song, you can use it in your movie provided you give me so much money. So copyright is actually a legal term showing that you have a right to copy your work and nobody else can copy or modify your work. Why should the law be there? So all the intellectual property laws have the same object. Why have these laws? One is to encourage creativity. If I know that my songs, my any kind of artistic work, my paintings are going to be protected and I can earn from it, I will be very encouraged to work more, create more and more creative work. So it rewards creativity. With creativity, obviously the social and economic development will be there, because any country to progress requires creativity and innovation. And it also, the object of the law is also to protect the creators from unauthorized use. If there is someone else using the copyright work, an infringement case can be filed on them. Now, when we saw about work, that is a particular copyright owner has an exclusive right to use his particular work, creative work, artistic work, musical work, he has a complete right, but he also has a right to adapt and make adaptations to it. Sir, what do you mean by the term adaptations? Adaptation means any kind of transformation or modification. So this is a very important, or you can say a definition that will come in, which I will take you through. One, what is the meaning of adaptations of copyright work? So first I need you to tell me who can adapt the copyright work. So obviously the author, the owner can adapt, make changes to the original copyright work. Common sense. Now what do you mean by adaptation is what is there. So they've given you various points and scenarios where I will give you practical life examples to understand the meaning of copyright and what is the meaning of adaptation in copyright. First, when dramatic work is converted into non-dramatic work. So let's say adaptation means a transformation. So there must be a dramatic work which has been converted into non-dramatic work. So let's take an example of the famous play of Romeo and Juliet. It was a very famous drama. Let's say out of that drama you have now made a book, a novel. It becomes a modification from drama to non-dramatic work. So from the dramatic performances, you are writing a novel is what is a one mode of adaptation. Second mode, this I think is very common and you will be able to relate because extremely new movies are there in this. Where literary work, literary means writings. Literary work are converted into non-dramatic work. So literary work are converted into dramatic work. So from a book we are making a movie. So this is based on the book we are making a movie. So can anyone tell me any famous examples? So if you go to see Chetan Bhagat, he had written a novel called as 5 Point Someone. So this was a literary work of Chetan Bhagat. Inspired from his novel, the movie 3 Idiots was made. Okay, so 3 Idiots was made as a Bollywood movie. It was later, in the South also there has been a remake of that movie as well. So that is also called as adaptations. Now whenever they are adapting, do you think the person making 3 Idiots has to pay to Chetan Bhagat some kind of royalty? Answer is yes, because adaptations also are protected. So if there is an adaptation, you have to pay the owner some kind of royalty. Simple. Or another very famous example is J.K. Rowling's book Harry Potter. We have so many movies made out of the book Harry Potter. Okay. Next is a pictorial version of a literary or dramatic work. Now what is happening? We are making from the dramatic work, drama, or certain literary work, we are making pictorial versions. A pictorial version means what? Pictures. So from some dramatic work or some literature, ancient literature, we are making images or pictures. So let me give you an example, a very famous example, the Amar Chitra Katha, okay, is a very notable example where the ancient religious scriptures and the ancient mythological events have been made into Chitra Katha for kids. So there was Ramayana, Mahabharata, okay, and various other events have been brought down into pictures and images to be seen. So that becomes a pictorial. So that Chitra Katha is actually a pictures. So for kids who might not be able to read, so they go through the Chitra Katha through scene 1, scene 2 and try to understand what it is there. So that is called as a pictorial version of a literature work, ancient work or dramatic work, pictures making out of writings. Then comes modification of musical work. Now again, modification, we've seen so many remixes, good remixes, bad remixes. Let me tell you, there was a movie called as Main Hu Dawn, or movie called as Dawn, and there was a song called as Main Hu Dawn. What happened is, there was a remix. One initial version was made by Amitabh Bachchan and the remix was made by Shah Rukh Khan. So Main Hu Dawn is a remix of an old Bollywood song. So obviously this is a modification, this is an adaptation. So the adaptation is also a right of the original work of the original creator. We have to pay him royalty. Any other kind of alteration of work is also called as an adaptation. So am I clear with what do you mean by the term adaptation? Adaptation means a change, and whenever you make a change in the original work, again you will have to pay some kind of royalty, or it should be with the consent of the owners. Now when I say the word communication to public, okay, now let's say I have made a YouTube video, we have so much YouTube content. Now when we do, what do you mean by the term communication? Now so all of us are content creators. Okay, if anyone is watching something on digitally, they are watching some digital content. So these content creators also are protected under the copyright law. Now there is, in this they say that, communication to public. What do you mean by the term communication to public? For example, when I put out my work so that it can be reached out to people, maybe through electronic means, through broadcasting, through any kind of method, satellite or any other way, through a live concert, it is called as communication to public, because you are putting out your performance to public. So let's see what do they say. So communication to public means any work available to be seen by public or enjoyed by public, it is called as communication to public. So if it is available to the public, it is called as you have communicated to the public. So one of this, let's say public directly. If there is a live concert, tell me one thing, Justin Bieber or we have Eminem, if they are having a concert in India and you are going to watch this concert live, don't you think it is a copyright? The entire performance is a copyright. Yes. So when they are doing the performance to public, where it is visible to the public, open, we can say that they are communicating their copyright work to the audience. When we have so much stand-up comedians, when they come, they put out their performance to the audience, it will amount to communication to the public. This will be treated as direct communication, where audience is sitting and you're performing. If I'm having a YouTube live lecture, it's a direct communication to people. Next, another mode is also given by means of display or diffusion. So if you see through a display of you're not seeing me live, right? You're seeing me on a laptop, on a phone. So that is through some display. Next, or according to you at your chosen time and place. So when you can watch your lectures at your time and place, this could be Netflix streaming services. So if you go to see Netflix, at any time you want, you can go and watch the show, right? So that is also communication to the public, because the audience can watch it at any time and any place according to when they want, regardless whether the public sees it or no, but you made it available to public. For example, if I have put out a series, Netflix series, there might be people who might not have seen also, but still it will be treated as, listen, it's on a public platform, it is available to public to see. Actual viewing is not necessary, is not what we are talking about. Available to public. Communication through satellite, cable to more than 1,000 household, okay, shall be deemed to communication to public. Obviously, when you're having these cable broadcast channels or a live cricket or football match, it's a communication to public. Now, today's generation, if you see, is following what they want. Some of them are beautiful singers. They love singing. They have a passion for singing. Okay, some like dance, etc. Now, these are all creations. These are all creative work of the artist. Now, when we see, I'm talking of artist. In the Copyright Act 1957, they have seen that, see, an artist is actually a creative person. They generally do it for their love. Okay, you will always see an artist performing out of love. They don't necessarily do it for money, and they are not sometimes very good commercially also. So what happens, there is exploitation of artists. There is a lot of exploitation of artists, and copyright law has come in to protect these artists at multiple points, which I will take you through also. What all safeguards are there, that listen, the artist song is there, you cannot copy it, you cannot remix it. The artist is there, you cannot take it for free, you cannot broadcast it, you have to mention the name of the artist. So many YouTube videos, if you are taking someone else's permission also, in the description you have to mention which is the song, who is the artist. You have to give, you have to honor the artist. So that all is there, creative work. So now we are saying what do you mean by sound recording also. Okay, if you see, there was a very famous song, Why This Colaveri Colaveri D. So that guy was singing and it became a huge YouTube sensation. That he went into a audio room and he recorded his particular song. So sound recording means a recording of sound from which sounds may be produced obviously regardless of the medium. So whether it is on a mic, whether it is without a mic, medium doesn't matter, but you have recorded your sound. It's called as sound recording. Author. So when I use the word author, what does it mean? Now obviously I told you that I have a book which is published, I have copyrighted it. So what happens is I am an author of a book, because when it comes to literary work, the author, the real author of the book, Shakespeare, Romeo and Juliet, he is the author of the book. A musical composer, A.R. Rahman, he has a famous song called as Jai Ho. In relation to musical work, the composer of the song, Arijit Singh, very famous singer again. In artistic work, the artist himself. A photograph, the person who takes the photograph. Nowadays we see photographers are also there. Okay, they are commercial photographers, etc. So the one who takes the photographs is the author. Cinematograph or the sound recording, the producer. In relation to any literary work, artistic, which is computer generated, the person who creates the work to be created, who causes the work to be created. Now again, this part also has now, from the example, computer generated means what? If I have made a drawing and then I get a printout of it, I have a architectural design and I have taken a printout of it, I have written a script and taken a printout, so even that is covered. Now the question came out that computer generated, for example, if there is a song, okay, that you go through ChatGPT and through AI, you create that song and ask them to mimic Eminem. This was a very famous case, you can check it out. So the songs are being sung in the voice of Eminem and AI is generating a completely new song. Who is the owner of this? So this is still very much in the courts to identify, and whether AI generated thing, who will be the owner. Okay, so this is settling down that the person cannot claim these kind of work. Okay, so this is still not there in the law, but extension from here is coming up that if I make a song telling AI to generate a song mimicking AI's Eminem's voice and telling them to create a new song, who will be the owner of this? Whether it be Eminem or whether it be the person who has seeked it in the computer. So as per US laws, it is Eminem who is the owner of this AI generated work. Now works in which copyright subsists. So very important. I told you with time copyright started to happen in many things. It started with literary work, dramatic work, musical, artistic, then it went on to films and now even sound recording. So section 13 subsection 1 says that copyright subsists in the following works. That means a copyright can be in what kind of things. Even it has now gone to computer programs. It has now extended to computer programs. Softwares are copyrighted. Now section 13 subsection 2. Now what does section 13 subsection 2 says? It gives you some conditions for subsection 1 to happen. What? So subsection 1 is saying that copyright is in your literary work, but subject to fulfillment of conditions of subsection 2. What does it mean? So it means that, listen, there is copyright in literary work, but only if you have fulfilled the conditions mentioned under subsection 2. So I will go and see that what is under subsection 2, right or wrong. So they are saying that copyright shall not subsist in any of the work unless, so whatever they have said, they are in subsection 1, they say it will not exist unless you fulfill the following condition. So very important to know the condition. So for published work, let's say the work has been published in and put in public domain. In case of published work, the work is published in India, or where the work is published outside India, the author is a citizen of India. Okay, so very simple. Two things for published works. So one example is, if imagine Chetan Bhagat, he is an Indian, has published a novel in India. Will he get copyright protection? Answer is yes. Clearly written that work is published in India. Second example is there is a performance of, let's say, Arijit Singh. Arijit Singh has gone abroad. Okay, and he has gone ahead and he's done a performance, live performance. Now he has the right over it, or let's say he has written the book abroad. He had stayed there and he has written the book abroad. So in that case, still it can be copyrighted in India. Why? Because where the work is first published out of India, but the author is a citizen, so still under subsection 13, subsection 1, it will fall, and protection under the act can be given. This applies even if the author is deceased. So let's say by the time he created it there, but unfortunately he died there only, but still the rights will be given to his legal heirs. So a novel written by an Indian author and it was first released in USA. So will it be entitled to protection? Answer is yes. Now we are talking of unpublished work, except architectural work, because architectural work is in point number 3. So unpublished work, let's say I have not yet published the work. It is still there in some prototype is still there. Okay, I have made some composition of a song and it is yet not published and made available to public. In case of unpublished work, the author is at the date of making the work is a citizen or domiciled in India. So the author, the person making the composition or the copyright work, who is there making of the work, is a citizen of India. So obviously citizen of India is always directly protected under the act, or not a citizen of India but domiciled in India. Domiciled means what? He has a domicile certificate, he is residing in a certain place of India. So that also you will get. A composer from Chennai writes a musical composition but has not published it yet. It is still available for copyright. So what happens is, I have now understand the logic why this is there. So what is the main objective is, even unpublished work is getting copyright protection. So let's say these entire notes that which you can see on the screen right now, this PPT presentation, I have sat and I have spent hours and hours of work to create this particular notes. Now when I have created this work, I have yet not published it, because once all my book is complete, then I will publish it. But before that, someone has taken and published it in some other platform and putting their names. I will be entitled to protection and I can file a case that, listen, it was unpublished, it has been leaked out, or it has been taken unauthorized use. See the dates. I have all these particular dates in my Word file or my PPT files. I have all these things in place. So even unpublished work is protected, which is a very good thing. And third, for architectural work, in case of architectural work is located in India. So a new mall is designed and built in Bangalore. So obviously it can be copyrighted in India. Why? Because the architectural work is located in India. So let's say there is a foreign architect, he is come in India to build a mall. Protection can be given under the act. Very simple, because it was built in India. The architectural design was in India. Now it may be noted that in case of a work of joint authorship, let's say there are two people who've written the book. Okay, so what is the condition? Is the condition to be fulfilled by any one of them or all of them? We've seen 13 subsection 2 is giving you those conditions: citizen of India, domiciled of India. So is all the joint owners have to be fulfilling the condition, or anyone? What do you think? So the answer is it should be satisfied by all the authors of the work. Next, they have said that listen, all of this is there, but two exceptions are there to section 13 subsection 2. 13 subsection 2 has two exceptions. So for these two exceptions, that is in section 40 and under section 41, the conditions need not be fulfilled. In 13 subsection 2, they have given you certain conditions to be protected. Even if these conditions are not fulfilled, section 40 and 41 protection can be given. Sir, what is it? So this talks about foreign work, and it talks about international organization, work of international organization. So understand what it is there. If Indian government has a treaty with some other foreign country, and we are saying that listen, there are these things are there and the conditions are not met, but in the treaty we have said listen, we will protect your citizen in India and you protect our citizen, reciprocal benefits will be given. So even if these conditions are not fulfilled, but the treaty is allowing it, so then we will continue. So section 40 and 41 is saying that India is having some agreements, bilateral treaties, some kind of organization, foreign work. So then the 13.2 does not have to follow. The conditions of the treaty will be followed. Now subsection 3. 13 subsection 3 says copyright ineligibility for infringing work in India. Very, very, very simple. And this is what we are talking of, dispute. Okay. So what does it mean? If imagine you come up with a film which is someone's other's work, obviously we will not give you protection. So copyright will not subsist. Copyright will not be given if it is a copy of someone else. So in case of a film, if the substantial part of the film is actually an infringement of someone else's work, we'll say what nonsense, you made a remake of this entire thing and you're fooling us. So protection will not be given. Second, same for sound recording also. We have seen so many times people are, the singers or the lyricist, or we can say the music composers are actually copying music of someone else. So if it is found out that if the work is infringing someone else's copyright, substantial work, there is extreme similarity, then obviously there will be a dispute, so we will not give you protection. Very simple. In case of any sound recording, protection will not be given if someone else's copyright work is being given. So in these two cases, in case of a film and a song, copyright protection will not be given. Why? Because it is following someone else's or copying someone else's thing. So till now you must have understood what you mean by the term copyright. So copyright is a right given, exclusive right given to the author of a particular, or the creator of artistic work, literary work, music composition, and now even architectural work and even computer softwares and programs. Now coming to another interesting point is section number 14. So section 13 and 14 are very, very important. Section 14 is saying that how long is section 14 is then we'll see the tenure. First they are saying that in what all copyright exists. So very simple. Let's take literary work. So I have my GST book, I have these PPT notes that I have made. So with respect to this copyright, what all powers do I have? So section 14 is saying copyright means an exclusive right to do. So I have a right to do something with my creation, or I have a right to give it to someone else, authorize someone else to do it. Any of these things. So what all I can do with respect to my book? I can reproduce it, I can issue copies, I can perform the work in public. So if we have a music, dramatic work, okay, we can do this. We can make a film out of it. We can translate the work. So let's say if it is in I have written the book in English. If I want that this book should go in, in another country, I can translate that book as well, or maybe translate into regional languages as well. Make any adaptation of the work. So very simple, that this all work I can do with respect to my copyright. Logical simple point that is given in section number 14. Same thing will be for others also. Let's say computer program. If I have written a computer program, okay, Microsoft, there is a computer program that I want to talk about. Okay, have you heard of Adobe Premiere Pro? Adobe Premiere Pro. So this is a very high-end editing software which is used by all the editors at a commercial level. Now what has happened is there is a new kind of software that has come, editing software, whose name is Blackmagic. Blackmagic company, they have launched a particular editing software which is DaVinci Code, the DaVinci Resolve. The DaVinci Resolve is taking the internet by storm. It's the future. Now let's say if DaVinci Resolve is a software, the author of the software is the company called as Blackmagic. Okay, so what all they can do now with DaVinci Resolve? So to act any of these particular specified thing, they can sell, commercially rent it out to someone, rentals of any copy of the computer program. So you can do any of the following acts with respect to literary dramatic work. That means all the points given here, in literary and dramatic work, all these can be done here. So let's say all of this I will call it as X, all these rights as X. So do any of the acts specified in literary work. So all the above work, so you can do. In addition to that, you can commercially rent it also, provided that when you're commercially renting it, the software should be the primary aspect that you're doing, then only it will come in. So it does not apply if the program itself is not the essential object of the rental. For this, commercial renting is when the main software is being rented, is what we are talking about. Okay, then comes copyright in rate of artistic work. So artistic could be musicians. There is a band, Black Eyed Peas. Okay, there is various other bands. There is Taylor Swift. And these are artistic work. What all they can do? So very simple. They can store it in any medium. They can do 3-dimensional, 2-dimensional work, depicted the way they want in any material or form. So very simple. Let's say there is a painting, artistic work, there is a painting. I can store that in any medium I want. I can make a 2D image, 3D image, however I want it. Now with respect to movies again, you can take a copy of the movie, you can commercially rent it, and you can communicate it to public. So you can broadcast it also. Sound recording, with respect to music, you can store it commercially. So the common word you will see is commercially rent it. Okay, and another common word you will see is making it available to public. Now when we say commercially renting, every time you saw in almost all the point is there that you will commercially rent it. So they are saying that the term commercially rent is for some money you have rented out, but an exception has been given. That commercial renting does not include any rental when this has been given for non-profit purpose by a non-profit library or a non-profit education institution. Now non-profit library or a non-profit education institution means those who receive grants from the government or are exempted under the Income Tax Act. So what does it mean? If imagine, very simple, there is a library or a non-profit work which government is recognizing, income tax is recognizing, then that will not come under commercial renting, because commercial renting by itself means profit oriented, but this is non-profit purpose. So it may be noted that commercial renting means to lease out any kind of software, sound, etc. for not for profit purpose by any of them. So if it is not for profit purpose, then it will not come out to commercial renting. Let's take an example. Let's say the government of India is running a marathon. Okay, they are taking up a marathon, or an NGO is holding a marathon, and for that marathon they are playing some music. Okay, or they require some software to conduct the operational part. They require some software. So this will not come under commercial renting because it is an NGO recognized by government doing this work. Then we talk about the song Tum Hi To Ho. Okay, a very nice song. It was sung by Arijit Singh and composed, and lyrics were by Mithun. Now let me ask you a situation. I want to see your interpretation. Then I will take you to the law and the case law. Now what happened is, Mithun, Arijit Singh, who is a singer, they have licensed it to someone that you can take our rights of playing the song to Mr. Company X. Let's say there is T Series. They have given it to T Series to play the song music. Now if this thing is being used in a movie, and actually this is given to T Series only, if it is being used in a movie, do we again require consent? T Series wants to further let it out to a movie. Do you again require consent of the owners? Answer is yes. Consent of Arijit Singh and Mithun is also needed. So let's see, with respect to sound, what all is covered. So there was a case law of Gramophone Company of India versus Super Cassette. Issue was whether using a sound recording to produce a cinematic graphic film infringes the literary work, dramatic work and musical work of copyright. See why? Because even though I'm playing the music, I am Arijit Singh, I am the singer, I have license, but I also have to ask to the lyricists who have written the song. So consent of all the creative artists need to be taken. So provision was provisions of law involved is section 14, where it says that copyright of sound recording does not include cinematographic film. So just because I give you a sound right doesn't mean that you can make a movie out of it. That further requires approval and gives the copyright holder of the literary, dramatic and musical work to make in cinematic films also. So if they give permission, obviously they can do. So we will see, I'll explain it with an example also. Owner of a sound recording cannot make a cinematic film incorporating a sound recording without the specific permissions from the creative artist. The owner of a sound recording, so let's say there is a person who is the owner of a sound recording. Here there is a difference between the author and an owner. Author is the original creator. Owner here is a person who's got this rights. So he has got rights for what? Rights of sound recording. Cannot you make a movie out of that sound recording? So let's take an example of which I had given of Tum Hi Ho. Bollywood song Tum Hi Ho, composed by Mithun. The lyrics was by Irshad Kamil and sung by Arijit Singh. The sound recordings was given to a music label, let's say T Series. Sound recording rights were given to T Series. But does that mean that just because you're given sound rights, they can also create a movie out of it? So answer is no. So just a second, I think my camera is got stuck. 2 minutes. Okay, so just we'll restart it. Okay. So I need you all to put in the chat box if I'm audible and visible. So I will continue with the balance part of the chapter as well. Okay. In the chat box, please. So it'll be great. I can start to move ahead with the lecture. Okay. Just waiting for your confirmation. Okay. Thank you so much, Sona. Okay. So we can continue with the chapter. Great. So let's start. Just waiting if someone else can also just put in if I'm audible and visible. So I'll quickly start with the chapter. Okay. So I just want to ensure that you all can hear it out clearly before I start. Okay. So great. So let's begin. So then, so let's start from here only. Let's start from this entire thing. So now I'll be talking of one of my favorite songs, that is Tumi Ho. The singer is Arijit Singh and the music composer is Mithun. Now let's say if these artists, see, one must have sung the song, that is Arijit Singh. The script must be written by songs must be written by someone, composed by someone, that is Mithun. And these artists must have given their rights of their sound of the song to T-Series. T-Series is the album which from all these artists they take these rights. Now the question is that Mithun and all of them they have given the song rights, that is the sound recording has been given to them. But if there is an adaptation to it, like from the song they want to make a cinematographic experience, they want to use it in a movie, then that will separately require consent. So this was stated in this particular case of Gramophone Company versus Super Cassette Industries. What was the question? Whether a sound recording to produce a cinematic film infringes on the literary work of the copyright owners, because if we take the sound and just use it in a movie, obviously the one who's written the literary work, who's actually written the song, we have very famous lyricists like Javed Akhtar, so they write songs, so even their consent is to be taken. So the conclusion is the owner of a sound recording's copyright cannot make a cinematographic film. So when I say owner, there's a difference between the author. Author is the original writer. When the author gives his rights to someone, they become permitted users or called as owners. So here we are talking of T-Series. In my example, the owner of a sound recording cannot just make a movie out of or use it in use the song in the movie. So I'll explain what they say. For example, the song Tumi Ho was composed by Mithun, the lyrics was by Irshad Kamil, and it was sung by Arijit Singh. Now the song's rights of the sound was given to T-Series. Now let's say there is a movie maker called as Rajkumar Hirani. He wants to use the song in his movie. So separate permission will be needed from all the creative artists, Mithun, Irshad and Arijit Singh. So this is a very important safeguard to the creative artists, where people used to take them for granted under these big companies, rules, regulations, contracts. Here they are saying that any adaptation you want to do, again go back to the creative artists and the authors and ask them. Now we are seeing the term of the copyright. Now we understood copyright exists in literary work, dramatic work, songs, softwares, but for how much time? Does a right remain, exclusive right remain forever? So the answer is no. Copyright ensures certain minimum safeguards for rights and protecting them. So we know copyright ensures safeguards, But what is a tenure? The main is the term of copyright. This is one of the most important. First, I'll tell you the summary. Very, very simple. You have to remember 60 years. 60 years is the thing. So copyright doesn't remain forever and the exclusive right is never forever. After a certain time period, it will go into public domain and public can start using that particular creative work. So for example, published work authors. Let's say my book. So for how long can I have complete rights over the book where nobody can use that book, use components of that book, till when? So the answer is 60 years from the author's death. So it's basically life of the author plus 60 years. So let's say if I will live for around 100 years. So life of the author plus 60 years. So that's the term. In case of joint ownership, from the death of the last owner. So let's say there are two co-authors. So when the one dies in 2010, the other one dies in 2015. So from 2015, 60 years will be counted. Very simple. Then we see for anonymous and pseudonymic works. Now what does anonymous work mean? We don't know who is the person. Sometimes people like to maintain a very private life, do not want to claim. There are a lot of writers, they want to leave it. Someone has written a book but kept his name unknown. Someone has written a beautiful shairi, a poet, but we don't know who he is. Just out of his pain he has written and has become a super hit. So that is also protected for 60 years from the date of its production, from its publication. It is protected. Obviously he's not going to come to claim because we don't know who he is, but if he comes during that period, then 60 years from his death. So he will get protection as well. So 60 years from his death. So I will say I didn't know that my poetry became so famous. It is there. I am the author of the poem and these are my rights. So from the author's death till 60 years will be given if that guy has come forward. Otherwise 60 years from publications. Now even you see so many times, if you see the Bitcoin owner, people don't know who he is. He kept himself very private. He doesn't want to claim any rights, etc. He's given that Bitcoin has been made and he's given the thing, he's published it. OpenAI published it. They don't want to claim something. So like that, there are people, okay, who want to do it. Posthumous work. Posthumous is after someone's death. So 60 years from the date of publication or adaptation, whichever is earlier. So very, very simple. Let's say if someone is there and we came to know that he's completed the book, publication was to be done, but unfortunately he died. So after his death, so he's already dead and we came to know that he's written a book. So we will take that book and publish it for 60 years, protection will be given. So protection will be given to whom if he is dead? Who is legal heirs? They can do whatever they want with the particular creative work. Next is movies. Again 60 years from the date of, so it's always when it's a literary work 60 years from death, or you would see in all the other cases 60 years from publication, from making it available to public. Sound recording 60 years from the date of publication. Government work 60 years from the first publication. Public undertaking work 60 years from the date of this. International organization work 60 years from the date of first publication. So it's very simple. Everything has the same thing. So now let's see what they have given. So the provisions are contained from section 22 to section 29. Term of the copyright and number of years. So I told you, term of the copyright in case of books, life of the author plus 60 years. So how do they word it? They say copyright shall subsist until 60 years from when the author dies. But now when the author dies, if he died in 2025, it will start from when? So 60 years from the beginning of the calendar year next following the year in which the author dies. So if he dies in 25, From 26 will be the first year and we will start counting 60 years. Term of the copyright in case of anonymous work, again 60 years, where if his identity is disclosed, then 60 years from his death. Copyright in posthumous work, again 60 years from it is publication. So everywhere it is from the publication. And whenever something gets copyrighted, then you have this particular symbol, copyright symbol. Now, assignment. Now, what do you mean by the term assignment? Section 18 talks about assignment. So, assignment basically means that you have the right to use it or to give to someone, to assign it to someone, to license it to someone, okay, to transfer it to someone, either for the full tenure or a part tenure or with limitation with respect to geographical territory, etc. So let's see. First one, section 18, assignment of copyright in the existing or future work. So either existing or future work also it is there. So let's say if I write, you pay me for writing 5 novels. So I have already made 2 novels, so it is existing work. Other 3 novels I will write, that also is in your name, future work. So copyright owners can assign their work to another person, either whole or in part, with or without limitation. Okay, and it can cover the entire term or also the part of it. It's my work, right? I can give it to whoever I want and for how much ever long and whatever conditions I want. Next, assignment of copyright in future work. So again, the time you cannot start only till the work gets created. So assignment in copyright has not been created or future work can be effective only when the work is actually created. So when the work is actually created, then the future work will be covering. From that time it will be counted. Assignment cannot be done before the work is created. Medium and mode of exploitation. Very, very interesting. Now, mode of exploitation means what? How can you use the assigned work? For example, if I have a work, I will give it to you. Take my book, you can use it. Or I have made a software. I'll say take the software, you can use it. Or I have a sound recording. I'll say take it. Now, medium of exploitation will also be mentioned. That you can, out of my book, you can use it and translate it, right, is given. But from my book, if you're making a movie, then I have to tell the mode changes, right? Then that mode is changing. So that again I will have to mention. So if assignment covers a medium or a mode of explanation that did not exist or was not in commercial use at the time, it is not applicable unless expressly given. For example, if I have given you a mode, I have said that all the rights are available to you. But there was a technology which came later after the assignment. So that right will not be given to you. For example, okay, so I'll give a very good example. So let's say my book is there. I have assigned it to Mr. X. I told Mr. X that you can take and translate it and use it to teach your students, and in colleges it can be given, etc. You can give me a royalty, etc. This was the discussion. But there was a technology which was not known, that was audiobooks, e-audiobooks, e-books or audiobooks. Now at the time of assignment, this technology never existed. So can Mr. X create an e-book and an audiobook without the consent of the author? So answer is no. So here he will have to take consent if he wants to use this new technology which was not available, that mode was not known at the time of assignment. So now if you see, you'll come to know that if the assignment covers the medium, okay, and it does not exist, that there was an assignment or a mode of exploitation was not exist, then you cannot use it unless without consent. So in an assignment for a book to a publisher, didn't mention ebooks because at that time the ebooks never existed. the publisher would not automatically have a right to publish it in ebook except with the consent of the owner. With respect to movies, cinematographic movies, so author of musical works included a film cannot assign or waive off his right. Now this is very interesting. You read it, it is on screen, and tell me what does it mean. Okay, the author of literary work, now see, the author, the original creator cannot assign or waive off his right to equal royalties except in case of movies. The reason behind it is actually to prevent exploitation of unfair agreements and deprive authors of their due compensation. This right remains with the legal heirs or their copyright societies. Any agreement to the contrary is void. This means that, okay, if there is an author and he has given his work to someone, to, let's say, I am calling them as owner, they are the authorized person. Now what are they saying? That this author cannot waive his right to equal royalty, to 50% royalty. Why like this? Means 50% of the royalty will be given. Law has fixed it because they found out that many times these big companies, they exploit the creative artists. They don't pay them, they don't give them royalty only. So law said that even if the authors want, they cannot do it. Agreement to the contrary is void. Who doesn't want money? Some people, they arm twist, and the cases came out that they have these one-sided agreements. So then law says that even if they want, they cannot get. The author will get the money. It will go to the legal heirs. This cannot be done. Only when you're giving it for movie cinemas, halls, that is allowed. Okay. For all other cases, 50% royalty will be given. Okay. Now coming to rights of authors in sound recordings. So authors of musically included in sound recordings cannot assign or waive off their right to equal royalties except if it is to their legal heirs and collecting society. So this will always be there. To them you can assign it. See, I'll tell you what is the concept of copyright societies. It will come in short time only. So what happens is, there is an author. Okay. Now these authors cannot go and find people who to give. They are just creative singers. So they cannot do all this administrative work of agreements, etc. So what they can do is, they assign their rights. They assign the rights. One is to legal heirs, obviously they can do. Legal heirs assignment is allowed. And they can even assign it to copyright societies. So copyright societies is actually an association of those people, of authors, of singers, of producers, like-minded category of people. Once that is there, the society is created. They assign all their rights here, and then the society will find customers. They will license it, collect the royalty, etc. So author can assign it to legal heirs and to copyright society only. In all other cases, you cannot waive off your 50% rights. Now this was a case of Video Masters versus Nishi Productions. Video Masters versus Nishi Production. Issue involved was whether assignment of video rights also covered satellite broadcast. Now I want you to tell me, I have already explained, I won't tell you the judgment or anything. I want you to tell me whether assignment of video rights also covered satellite broadcast. So the answer is very simple, that if I am giving video rights, it is only video rights. It does not cover all other modes of commercial activities. So it does not include. No. How do they say that, listen, with respect to my work, there are multiple ways of sharing my work. It could be through television, it could be through news channels, it could be through radio, it could be through satellite, it could be through live, it could be through YouTube, digital streaming, anything. So the owner can have distinct copyrights with respect to the same work. So one person I can give rights on radio, one I can give it on news channels, one I can give it on territorial. I can say that you use it in USA. So I have rights in all different places. So I have independent copyrights in respect of each format. Separate assignments can be done for my video format to someone, for my audio format to someone, for my literary work to someone, all of which I can do. So all are distinct entitlements, all are different methods of your same use. So the High Court has clarified that copyright in one format if you get does not mean that you have automatically got in other formats also. The agreement should mention that I have rights in one format, two format, three format. But if I only get an audio format, that means I have only rights to audio methods only. Now section 19, let's go to section 19. Section 19 talks about modes of assignment. Very simple, very easy. Is oral assignment allowed? Can the author say that you can use my song in words? No written agreement. Allowed or not allowed? I am the author, I give it in words. Allowed or not allowed? Answer is not allowed, because there will be disputes and then again you will come to court and it becomes impossible to manage. So they say, listen, if there is an assignment, it has to be in writing. It should mention all the royalty that you will get, the territorial extent to which it will be used, all the work, the duration, everything will be given. Also, one very interesting thing is given that if I have assigned it to you, I have given the rights to you, you have to use it. If for 1 year you have not used it, I am the assigner, you are the assignee. I gave you my song, you are not using it only. So within 1 year it will lapse, the rights will lapse. That law says that if it is there, they should use it. If for 1 year that person whom you gave has not used it, then his rights will lapse by non-use. Void assignment. Okay, anything which goes against the Copyright Acts is void. And cinematographic films also, the author's right is there to claim an equal share in royalties, except if it is in a cinema hall. So there is a very nice case that will come up. I will show you. Section 19 was very simple, that it should be in writing only. Then disputes, because there is possibility that there will be disputes in assignment. So revocation for inadequate exercise, that a commercial court to revoke copyright assignment. Revoke means to cancel the assignment if the assignee fails to sufficiently exercise this for a period of 1 year and the assigner is not at fault. Again, what are we doing? We are seeing revocation. Revocation means what? A court is cancelling the rights of the assignee. Why? Because he is not using only the particular license, so that can be a ground. Second, resolution of assignment dispute. That whenever there is a dispute with respect to assignment between the assigner and assignee, dispute arises, it will go to a commercial court. Down they have given you a commercial court is a high court or any other dedicated court. Protection for assigner. Law ensures protection. All the laws we see are to protect the assigners only. And law ensures that the commercial court cannot revoke any assignment unless the terms are harsh on the assigner. Okay, because see what happens, we are always protecting creative artists, because all these music companies are sharks. They have these one-sided agreements and try to harass these singers, dancers, performers, etc. So they've always spoken to the favor of assigners. Interim orders can also be given for revocation during if I'm revoking someone's license, I realize that they did one-sided agreement. So they will also can pass interim order, because final judgment will take time. In pending case also they can give some interim or injunction in between. Time frame, what they say, that no revocation can order be given within 5 years from assignment. So additionally, commercial court aims to resolve the disputes within 6 months. So revocation, on these grounds, they are saying 5 years of assignment cannot be done within that. give the assignee also some time. Now this is the case that I'm talking about, Venu Gopala Shetty versus Dr. Suryakant Kamnath. So in revocation what happens, if this guy is not using only, and they are saying that for 5 years we will say that it is lapsed if it is not used for 1 year, but proactively revocation will be done after 5 years only if the commercial court has feel so. Now let's see, Venu Gopal, I have already explained, it will be really fast. Validity of original assignment, is it allowed or not allowed as per section 19? So court's ruling is oral agreements are invalid. It is necessary to have mandates written agreement, that is what it is given, and they have to comply. It has to be signed by the author. Okay. Then comes licenses. Compulsory license, we will see what all they have given. Section 30. Here they have just given you the section numbers. License by owners, compulsory license which will come, which is important from here. Now license by owners, let's see. This is, we are dealing is with section number 30. What it is saying, let's see. The exclusive right or exclusive license is given to the owners. The author or the copyright owner has exclusive right in his creative work and he alone can grant a license. Simple, yes or no? Obviously he alone is the owner and he alone can grant the license. Section 30 empowers the owner of the copyright to empowers the owner of this in any existing work or any future work to grant any interest in right to license in writing. In case of license in any future work, it can only be given once it is the future work comes into existence. This we've already seen. In if for some reason someone dies, then it can, the rights will be given to the legal heads. Very simple. Section 30 owners' rights have been given. Now a very interesting concept of compulsory licensing. Now compulsory licensing we'd also seen in patents, that whenever we give these kinds of copyright protections, we expect you to use it and help the people of India. If at all you are not using the particular intellectual property, the country will not grow. In such case, an interested party can apply for compulsory licensing, that listen, this guy is not giving me the license, the author is not giving me the license, or the author is not giving me at reasonable terms. They will go to the controller. The controller, if they find on a complaint, the commercial court can grant a compulsory license, that listen, this guy is not using, you take these terms and use it. Because law says that we are granting you protection and all this, that you will use in India. So let's see. Section 31, 30 we saw, now we are seeing section number 31. If you are not helping the public, you are withholding it from public, then it is not allowed. Section 31, if at any time during the term of the copyright a complaint is made to the commercial court that the owner has refused to publish it or not allowing it to be published, okay, and is withholding it from public or has refused to allow the communication to public by broadcast, okay, and the complaint considers reasonable on the terms complainant feels reasonable, that reasonable royalty is not charging, at least he can file a complaint in the commercial court and an opportunity being heard will be given. If it is satisfied that listen, this is very very necessary, this is necessary and to be known, then they will grant a compulsory license. Just a sec. Okay, so if it is satisfied that the conditions are actually not reasonable, then the registrar of copyrights will the commercial court will direct the registrar of copyrights to grant to the complainant a compulsory license to republish the work, perform the work in public, broadcast the work as it is necessary. For example, there is a very important documentary that has been made, and it is very very useful to the public, and this guy is not, he's hiding it. After getting copyright protection, then we will send commercial code and complain and get it done. And whatever natural royalty he should get, court will determine and give that to him. Now this was with respect to published work. Now we are seeing a compulsory license also in unpublished work. That is section number 31A. Section 31A allows people to apply licenses for published work that are unpublished, okay, or withheld in India when the author is deceased, unknown, or non-traceable. If we find that there is some important work he has done and he is not traceable, then even the unpublished work can be asked through a compulsory license to be published, and the natural royalty will be given to the legal heirs. Process involves advertising of the intention to apply, so there will be an advertisement telling that, listen, this is very important unpublished work. Unfortunately, the author is deceased, unknown, or untraceable. Okay, we will apply our application to the commercial court, and if the commercial court, whatever royalty they want, they will identify the legal heirs and give it to them. Even if it serves as national interest, the government of India can require its publication. Same concept if there is a very important documentary or very important article which is in but unpublished yet, so compulsory license can be ordered for that publication as well. Now we're talking of radio mirchi or any kind of broadcasting rights and of sound. Let's see, section number 31D, statutory license for broadcasting of literary work and musical work and sound recording. So let's see the very first one. My question is, can Radio Mirchi, it's a radio channel, can Radio Mirchi play any person's song, any artist songs without their permission? Yes or no? Any song they want that we are playing next, XYZ latest hit, we are playing. Do we require consent of the owners? Answer is absolutely yes. You're broadcasting through of someone else's copyright work. You cannot do it without taking their permission. So first one is broadcasting organizations can broadcast any kind of musical work but subject to the regulations. Prior notice, must provide a prior notice of their broadcast plans. Now they will tell them that when they are going to broadcast, how many times it will be shown, for how much duration will be shown, what is the territorial coverage, who is the audience, and how much royalty will be given. Separate rates will be given. If it is for radio, it will be less, but if it is a television broadcasting, it will be much more. The commercial court can decide the royalty terms. Attribution, they always have to tell, you will always see XYZ is the author, XYZ is the performance, their name has to be announced. So they will always say a song by Arijit Singh we are playing next. That has to be told, it's a rule. Alterations, unauthorized changes to the work. Unauthorized changes to the work. They cannot play a remix, they cannot change, requires consent of the owner. Records and inspection, broadcasting organization must maintain a record of all their reports and their consent letters, etc. Okay. So Radio Mirchi, I told you, a popular radio station, that is Radio Mirchi, intends to broadcast the song Tum Hi Ho from Bollywood movie Ashiki 2, which is a published musical work and sound recording. Before playing the song, Radio Mirchi must comply with section 31D. Then comes termination of license, section 32. Now very simple, if someone has been given a permission, a license to translate the work, now this is a little weird way what they are saying. Listen, if someone has been given a permission to translate the work into a particular language, I have given you my book to translate into Hindi, one into Marathi and third one into Malayalam. Now the owner, the copyright owner, can cancel the permission. If I have given you the permission, I can cancel the permission also. I will cancel by giving you a notice. They are giving you the time of the notice also, that a sufficient notice has to be given, and I can publish it myself, and then I will publish it. If I decided that I want to publish the same thing in the same language, then I will do it. Now coming to a very important concept called as copyright societies. Market is important. What is a copyright society? So what happens, let's take an example of singers. So we have a lot of singers. Now tell me, there are so many people who require the songs. Maybe I require the song of Arijit Singh. Okay. So let's say I could call them as users or those who need. We need their songs. But isn't it very difficult to trace every single singer, have an agreement with them, negotiate the royalty? Where someone will tell her, "Yeah, Rahman, please give me a discount of 50%. They will go and tell, any Asha Bhosle that please give me at a lower price. So they will say, what nonsense. The singers and artists don't want to engage in all this. But they definitely want to give their song for royalty. So what do? So all these people, all these singers, performers will form an society. So they will make a copyright society. All these will be members here. They will become members here. They will give them some maintenance charges, etc. will be given here, so that the society can hire marketers, can hire legal people for contract drafting. For any infringement, they will look into the matters. So they assign their rights. They assign their songs and their rights to the society. And the users also don't have to find out separate artists. They will simply apply to the society. There will be an onboarding team and they will negotiate, etc. So royalty will be given here to the society, and this society will then disburse it after all the expenses meeting out, and then they will give it to the particular singer. So this is a copyright society. The copyright society is to protect its members. It's to collect the copyright work, broadcast it and give it to others through contracts, and collect the royalty and then give it back. So very good concept. And royalty. So today if I want a song, I don't have to run around to the creator. I directly go to that association and ask them. Okay, so this is the entire concept. Function of the society. What was the primary function? They will license the work of the copyright holders. Then they will monitor and they will collect the revenue and then distribute the revenue to the members. There are a lot of copyright societies in India as well. Okay, so if you see an Indian Singers Rights Association. So if I want, I will just go to the association, say that listen, these artists are there, I want songs of these artists, what is the price, everything will be listed. I will pay and get another right to use the song. Now registration of this copyright society. Prohibition on authorized unlicensing. Prohibits anyone from issuing licenses for copyrighted works without authorization. So no person can start licensing without getting registered as a copyright society. Individual copyright owners can still grant license for their work while being a part of the society. So if they are a part of the society, I have given it to the society, but I can also sell it individually also. My rights. Now section 33 provides, subsection 3 says the central government registers an association of persons as a copyright society after taking into account the following factors. So people will have to come together and say that we want to make a society and this will be for all our mutual benefits. So the central government will look at who are the interest of these persons who are coming, how it will help the public, and whether they will be able to professionally run this particular society. Now renewal of registration. So normally 5 years is given and renewal is also for 5 years. But if at all after inquiry they come to know that they are working in a detrimental manner, they can even cancel the registration. Then administration of the rights of the work by copyright society. So what is the work? Very, very simple. They get exclusively, they get the rights, they can authorize whoever they want. So exclusive authorization and international agreements. Copyright societies can accept authorization from authors and rights and which allows them to issue licenses. and collect license fees. So again, there is the author, that is the original creator. The author will give this copyright society the rights, and these copyright societies will go and take from clients. Let's call them clients. Clear? So they can give licenses and particular rights. Withdrawal of the authorization, authors. Okay, authors can withdraw their authorization if they wish to. International agreements, they can enter into agreements with foreign societies also. Now imagine if I want my song, which it can be used abroad also. So if you go to see, there was an Indian song which was used in Black Eyed Peas. So even our songs can be used abroad also. And I think even in Slumdog Millionaire they had used some Indian songs. So copyright society has the power to issue licenses, collect the fees, distribute it among the authors, and perform such other functions as may be needed. Okay. Now control over the copyright society by the author. Very, very simple. All the authors only have made the society, so they will only have collective control over the society. They will make a chairman, secretary, a governing body like how we have in our society, and they will collectively on basis of majority votes decide. Every member will have a right and equal membership in the right, and there should not be any discrimination. Okay, so that is it. From this point onwards, we will do it tomorrow. Okay, till here I need you all to confirm if I'm audible and everything was clear to you. Okay, was everything perfectly clear? From this point till the end, I will take it tomorrow. Okay, I need you all to tell me in the chat box if you all were able to understand what all I have explained. I have completed all the chapters, okay, or every single chapter in depth I have done. This is the last chapter of this thing, and then 40 marks I have beautifully covered it in this series of lectures. Okay, and also it's my request, if it is possible, inform any of your friends also about us, especially your WhatsApp and your Telegram groups. Let them know about us. Okay, that's it. You can join our WhatsApp groups. Links are in the description. I will see you all tomorrow again. Thank you so much and good night.